Hi everyone, welcome back. So this is regarding interpretation clause in Evidence Act 1872. So in Indian Evidence Act interpretation clause, we have the interpretation for court, fact, relevant, fact in issue, document, evidence, proved, disproved, not proved, India, and the expressions certifying authority, etc., are also discussed here with respect to this. And then we have child witness, chance witness, inimical witness, rustic witness, interested or partisan witnesses, then injured witness, motive, affidavit of witness, video conferencing, circumstantial evidence, variation between medical and ocular evidence and its effect, evidence ambit of. So we have these many expressions for under the interpretation clause, that is section 3 of Evidence Act. So we are gonna read out the bare act. What are they? So court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. So here the expression judges is to be understood with respect to CPC section 2 or in IPC section 19, and for definition of district judge, the General Clauses Act section 3. So with respect to Indian Evidence Act, court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Here in this expression, judges is referred to the meaning as in section 2 of CPC or section 19 of IPC, or with respect to district judge, one has to look into the General Clauses Act section 3, and magistrate is given with respect to section 3 subclause 32 of General Clauses Act. District judge is discussed in section 3 subclause 17 of General Clauses Act, and magistrate is discussed in section 3 subclause 32 of General Clauses Act. So with respect to magistrate, section 3 subclause 32 of General Clauses Act, then CRPC. We have to consider both with respect to the expression of magistrate. Now next we have is fact. Under Indian Evidence Act we have fact interpretation clause section 3. Fact means and includes 1. Anything, state of things or relation of things capable of being perceived by the senses. That is anything, state of things or relation of things capable of being perceived by the senses. And the second one is any mental condition of which any person is conscious. So fact includes two things. The first one, anything, state of things or relation of things capable of being perceived by the senses, and the second, any mental condition of which any person is conscious. And we have some illustration here. A, that there are certain objects arranged in a certain order in a certain place. That is a fact. Now B, that a man heard or saw something. That is a fact. C, that a man said certain words. That is a fact. D, that a man holds a certain opinion and has certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or was at a specified time conscious of a particular sensation, is a fact. And E, that a man has a certain reputation. That is also a fact. Now the next we are going to look into relevant. What is relevant under section 3 of Evidence Act 1872? So relevant, one fact is said to be relevant to another when the one is connected with the other in any way of the ways referred to in the provisions of this act relating to the relevancy of fact. And relevancy of fact is discussed from section 5 to section 56, which also includes the admission and confession. Now fact in issue. Fact in issue as per Indian Evidence Act section 3. Here the expression fact in issue means and includes any fact from which either by itself or in connection with other fact the existence, non-existence, nature or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. So, once again, either by itself or in connection with other facts, the existence, non existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. We have an explanation to this, that is, whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. And the illustrations: A is accused of the murder of B. At his trial, the following facts may be in issue: that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A, at the time of doing the act which caused B's death, was by reason of unsoundness of mind incapable of knowing its nature. So, all these may be relevant facts. Now, the next one is document. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. So, document is also discussed under IPC section 29 and General Clauses Act section 3 subclause 18. So, document is also discussed in IPC section 29 and General Clauses Act section 3 subclause 18. Now, with the illustration with respect to document, a writing is a document. Words printed, lithographed, or photographed are documents. A map or plan is a document. An inscription on a metal plate or stone is a document. A caricature is a document. Now, the next expression discussed under Interpretation Clause of Indian Evidence Act 1872 is evidence. Evidence means and include 1. All statements which the court permits or requires to be made before it by witnesses in relation to matters of the fact under inquiry. Such statements are called oral evidence. And the second one, all documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. So, evidence interpretation is given in two circumstances, that is in oral evidence and with respect to documentary evidence. All statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. Now, all documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. Now, next we have expressions of proved, disproved, and not proved with respect to Indian Evidence Act. So, proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So, that is proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstance of the particular case, to act upon the supposition that it exists. Now, what is disproved? So, a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. So, disproved is the exact opposite of proved. Now we have one more term, that is not proved. So proved and disproved is the exact opposites. Now what is not proved? So not proved is a fact is said not to be proved when it is neither proved nor disproved. So not proved comes in between proved and disproved. It's neither proved, it's nor disproved. So that is the interpretation given for proved, disproved and not proved in Indian Evidence Act section 3. Now India. India means the territory of India excluding the state of Jammu and Kashmir. Now the state and states which are inserted by currently this exception for Jammu and Kashmir is taken away. Now India means the territories of India, that is the whole of India, and also even if it is outside the territory of India, if it is under the Indian government's control, central government's control, parliament's control, then that is considered as territory of India. Now the next we have to look into the expressions certifying authority, electronic signature certificate, electronic form. All those have the same meaning as prescribed in Information Technology Act 2000. Now we have a few comments here. That is affidavits. Affidavits are not included in the definition of evidence in section 3. So it is to be noted that affidavits are not included in the definition of evidence under section 3 of Evidence Act 1872. Now, and it can be used in evidentiary evidence only if court permits. So it doesn't mean that the affidavits cannot be an evidence. It can be used in evidence, but only if the court permits. And here this is and it should be given with sufficient reason why it is permitted to be used as evidence. And this was held in a case, that is Sudha Devi versus MP Narayanan. Sudha Devi versus MP Narayanan, AIR 1988. So in this case, the court held that affidavits are not included in the definition of evidence in section 3 of the Evidence Act and can be used in evidence only if the court permits. That is, it to be used for sufficient reasons. Now, appreciation of evidence. In order to appreciate the evidence, the court is required to bear in mind the setup and environment in which the crime is committed, the level of understanding of the witnesses, the over-jealousness of some near relation to ensure that everyone even remotely connected with the crime be also convicted, everyone's different way of narration of same facts. These are all only illustrative instances. So that was held in Ganesh K. Gulve versus State of Maharashtra in 2002. So in Ganesh K versus Gulve versus State of Maharashtra 2002, the court discussed about the appreciation of evidence. As in order to appreciate the evidence, the court is required to bear in the mind the setup and environment in which the crime is committed. So the first one is the setup and environment in which the crime is committed. Then the level of understanding of the witness and the over jealousness of the near relation who wants even the remote persons to be convicted. So all these should be considered by the court to appreciate the evidence, and that was held in Ganesh K. Gulve versus State of Maharashtra, AIR 2002. Now, the fact that the name of the witness do not appear in the first information report, that is the FIR, by itself cannot be a ground to doubt their evidence, and that was discussed in Raj Kishore Jha versus State of Bihar 2003, AIR 2003. So this is with respect to the comments that are given under section 3, that is the interpretation clause of Indian Evidence Act. We discussed 3 case laws so far, that is Sudha Devi versus MP Narayanan, that is AIR 1988, where the court said that affidavits are not included in the definition of evidence under section 3 and they can be given evidence value if only if the court permits, if it is to be used for sufficient reasons. And another case law is Ganesh K. Gulve versus State of Maharashtra, AIR 2002, which discuss about the appreciation of evidence, where the court has to consider the circumstance and the setup where the crime was committed, the level of understanding of the witnesses, and also the over jealousness of the near relatives, and also consider that different people have a different way of narration of the same fact. All these should be considered by the court. And further, in another case, Raj Kishore Jha versus State of Bihar, that is 2003, AIR 2003, Raj Kishore Jha versus State of Bihar 2003, the court said that just because a name was not mentioned in the FIR is not a ground to doubt doubt the statements or the evidence given by that person. Now, we have a maxim, that is falses in uno, falses in omnibus. Falses in uno, falses in omnibus. So this maxim means that the has no application in India and the witness cannot be branded as a liar. So this maxim, falses in uno, means falses in omnibus. It means that if it is if something is false in one part, it is false in the whole part. So this maxim is not made applicable in India, and the witness cannot be branded as a liar merely because some of the accused persons have been acquitted, though evidence against all of them so far as direct testimony went was the same, does not lead as a necessary corollary that those who have been convicted must also be acquitted. It is also open to the court to differentiate accused who had been acquitted from those who are convicted. And this was held in Gangadhar Behera versus State of Orissa. So in the case of Gangadhar Behera versus State of Orissa, that is 2002 case, and as well as that, and Nadodi Jayaraman versus State, that is a 1993 case. So in both these cases, that is back in 1993 in Nadodi Jairam versus State, as well in 2002 Gangadhar Behera versus State of Orissa, the court said that the maximum of falses in uno, falses in omnibus is not applicable in India. Just because a part of the accused, some of the accused were acquitted, doesn't mean the others who were convicted is also to be accused. The meaning of falses in uno, falses in omnibus is that if one part of something is false, the whole of it becomes false. That is not applicable in India, and we cannot brand the witnesses as liars. So that is with respect to the comments that was discussed under section 3, that is the interpretation clause. And now, a statement of the approver implicating several accused could not only be corroborated generally but also qua each accused. However, independent corroboration of every particular circumstance for independent source is not necessary, and that is discussed in Devendran versus State in 1998. So here the statement of the approver implicating several accused persons could not only be corroborated generally but also qua each accused. However, independent corroboration of each particular circumstance from independent sources is not necessary. That was discussed in Devendra versus State in 1998. Now we are going to discuss about some of the types of witness discussed under the interpretation clause of Indian Evidence Act, and we have about 6 witnesses discussed under interpretation clause of Indian Evidence Act. That is child witness, chance witness, inimical witness, rustic witness, interested or partisan witness, and injured witness. So a child of tender age can be allowed to testify if he has a intellectual capacity to understand questions and give rational answers thereto. So a child witness of tender age can be made a admissible witness if that child has an intellectual capacity to give rational answers to the questions put forward to him, and that was held in Ratan Singh Dalsukh Bhai Naik versus State of Gujarat in 2004. Ratan Singh Dalsukh Bhai Naik Ratan Singh Dalsukh Bhai Naik versus State of Gujarat in 2004. As a child witness is prone of tutoring, court should look for corroboration, particularly when the evidence betrays the trace of tutoring. That was held in Arbind Singh versus State in 1994. Arbind versus State in 1994. When it is established that the child witness is under the influence of tutoring, it is not safe to rely on such evidence, and that was held in Chagan Dame versus State in 1994. But when the minor daughter of the deceased not only connected her mother with the murder but also described the role played by her, and there is no material discrepancy in her evidence, the version of such child witness is reliable, and that was held in Kamala Sethi versus State, and that is one of the important cases. Kamala Sethi versus State, 1994. The law recognized the child as a competent witness, but a child, particularly at a age of tender age of 6 years, who is unable to form a proper opinion about the nature of the incident because of immaturity of understanding, is not considered by the court to be a witness whose sole testimony can be relied without other corroborative evidence. The evidence of the child is required to be evaluated carefully because he is an easy prey to tutoring. Therefore, always the court looks for adequate corroboration from other evidences to the testimony, and that was held in Bhagwan Singh versus State of MP. Bhagwan Singh versus State of MP, and that is a 2003 case. So, with respect to child witness, we discussed 5 cases, that is Ratan Singh Dalsukh Naik versus State of Gujarat 2004, then Arbind Singh versus State 1994, Chagan Dame versus State 1994, Kamal Sethi versus State 1994, and finally Bhagwan Singh versus State of MP 2003. And the next category of witness discussed here is chance witness. The expression chance witness is borrowed from the countries where every man's home is considered his castle and everyone must have an explanation for his presence elsewhere and in another man's castle. It is quite unsuitable an expression in a country where people are less formal and more casual, at any rate in any other manner explaining their presence, and that was held in Tangayya versus State of Tamil Nadu. So, chance witness is where a person happened to be in a place where he usually wouldn't be there. So, suppose Mr. A is in A's house and something happened in A's house. Mr. B happened to be in A's house when such an event took place. So, here B is a chance witness. So, in Tangayya versus State of Tamil Nadu 2005, the court said that the term expression chance witness is something that is borrowed from other countries where a man considers his castle, his home as his castle, and everyone must have an explanation for the presence of being in another one's castle or elsewhere. So, in our country, especially in Tamil Nadu, Kerala, etc., people tend to go to the other house, have a conversation with the neighbors, spend time at the neighboring house, etc. So, in such a scenario, this cannot be, this expression is not relevant. That was held in, that the expression of chance witness is not relevant, was held in Tangayya versus State of Tamil Nadu 2005. Even though the witness is a chance witness, but he gives cogent reasons for his presence near the scene of occurrence, the evidence of a chance witness is not unreliable. So, the evidence of a chance witness should be taken in consideration if that person gives a reason, a solid reason for why he was there at that time, at the occurrence of the event, why he was there. Now, the third category, two case laws were discussed with respect to chance witness, that is Tangayya versus State of Tamil Nadu 2005 and State of UP versus Roop Singh 1995. And the next category is inimical witness. The testimony of inimical witness has to be considered with caution. If otherwise the witnesses are true and reliable, their testimony cannot be thrown out on the threshold by branding them as inimical witnesses. It is a well settled principle of law that enmity is a double-edged sword. It can be a ground for false implication, it can also be a ground for assault. So, here enmity is a double-edged sword. It can be a ground for false implication and also for assault. Therefore, a duty is cast upon the court to examine the testimony of inimical witness with due caution and diligence, and that was held in Ramashish Rai versus Jagdish Singh 2004. Ramashish Rai versus Jagdish Singh in 2005. When even the evidence of inimical eyewitness were corroborated by other evidence including medical evidence, then their evidence were reliable and conclusively proved the case against the appellant. That was held in Dalip Singh versus State AIR 1997. So with respect to inimical witness, two case laws were discussed. That is Ramshish Rai versus Jagdish Singh 2005. Ramshish Rai versus Jagdish Singh 2005 and Dalip Singh versus State 1997. Now the fourth category of witness discussed here is rustic witness. So far as the evidence of a rustic witness is concerned, the court is not to judge his evidence by same standard as that of the urban witness. So once again, the court is not to judge his evidence by the same standard as that of urban witness, and that was held in Ranbir Yadav versus State AIR 1995. Ranbir Yadav versus State AIR 1995. In this case, it was held that as far as the evidence given by the rustic witness is concerned, the court shall not judge his evidence by the same standard as that of the urban witnesses. Therefore, the contradiction of such witnesses as to the time of occurrence is not sufficient to discard the evidence of such a witness, and that was held in Pandapa versus State 1997. In Pandapa versus State 1997, the court held that the contradiction of such a witness, that is rustic witness, as to the time of occurrence is not sufficient to discard the evidence of such a witness. That was held in Pandapa versus State. So with respect to rustic witness, we have two case laws, Ranbir Yadav versus State AIR 1995 and Pandapa versus State 1997. The next category of witness is interested or partisan witness. It is not that the evidence ought to be discredited by reason of the witness being simply an interested witness, but in that event the court will be rather strict in the scrutiny as to the acceptability of such evidence, and that was held in State of Haryana versus Ram Singh 2002, AIR 2002. In State of Haryana versus Ram Singh AIR 2002, it was held that it is not that the evidence ought to be discredited by the reason of the witness being simply an interested witness, but in that event the court will rather be strict in the scrutiny as to the acceptability of such an evidence. Now, the fact that some of the witnesses were relatives of the victim's family is no ground to reject their evidence as untrustworthy. In law, what is expected to analyze and scrutinize the same with due care and caution before accepting or acting upon the same, and that was held in Malhu Yadav versus State in 2002. Malhu Yadav versus State in 2002. So in this case, it held that just because the witness is the relative of the accused doesn't discredit their witness, just that the court has to analyze and scrutinize more strictly and with caution. So with respect to interested or partisan witnesses, two case laws, that is State of Haryana versus Ram Singh 2002 and Malhu Yadav versus State 2002. And the last category of witness discussed under Interpretation Clause of Indian Evidence Act 1872 is injured witness. That is the sixth category, injured witness. The trial court was not justified in discarding the evidence of injured eyewitness in toto on the ground of inimical disposition towards the accused or the improbability of narrating the details of actual attack. True, their evidence has to be scrutinized with caution, taking into account the factum of the previous enmity and the tendency to exaggerate and to implicate as many as possible. But on a perusal of the evidence tested in the light of the broad probabilities, the High Court was justified in reaching the conclusion that the prosecution witnesses are natural witnesses and they could not have concocted the case against the accused without any base, and that was held in Suresh Sitaram Survey versus State of Maharashtra in 2003. Suresh Sitaram Survey versus State of Maharashtra in 2003. It discussed about injured witness. The statement, the injured eyewitness in toto cannot be discarded. The evidence provided them cannot be discarded on the ground of inimical disposition or the probability of exaggeration in their explanation, and they have to considered with caution and scrutinized. The evidence has to be considered with caution and scrutinized. So that was held in Suresh Sitaram Survey versus State of Maharashtra 2003. So 6 categories of witnesses were discussed under Interpretation Clause of Indian Evidence Act 1872, that is child witness, chance witness, inimical witness, rustic witness, interested or partisan witness, and injured witness. Now we have a few more expression that was discussed under Interpretation Clause, that is motive. It is a well settled that merely because motive is neither alleged nor proved, the same would ipso facto not affect the prosecution case. But in case there are other circumstances to create doubt regarding the veracity of the prosecution case, this may become material. So that was held in Dhanamjay Shankar Shetty versus State in 2002. In Dhanamjay Shankar Shetty versus State 2002 case, it was held that ipso facto the alleged or proved motive is not material, but when there arises a doubt regarding the veracity of the prosecution case, then the proving of motive becomes material, and that is held in Dhanamjay Shankar Shetty versus State 2002. Now, when the evidence of the eyewitness and other evidence are of unimpeachable verity and inspire confidence, absence of motive for murder is immaterial. So, meanwhile, we discussed when the proving of motive can be of material fact, and general rule is that it is immaterial, and that is when the evidence of the eyewitness and other evidences are unimpeachable verity. They are of unimpeachable verity and inspire confidence, then absence of motive for murder is immaterial, and that was held in Kabiraj Tudu versus State 1994. Kabiraj Tudu versus State 1994. So then we have affidavit of witness. The practice adopted by the defense side in getting the affidavits of witness in advance is to be deprecated. That in a way amounts to an attempt aimed at dissuading the witnesses from speaking the truth before the court. That was held in Rachapalli Abullu versus State in 2002. Rachapalli Abullu versus State 2002. In this case, the court held that the practice adopted by the defense side in getting the affidavits of witnesses in advance is to be deprecated. That in a way amounts to an attempt aimed at dissuading the witnesses from speaking the truth before the court. Now, video conferencing is the next expression discussed here. evidence can be both oral and documentary, and electronic records can be produced as evidence. This means that evidence, even in criminal matters, can also be by way of electronic records. This would include video conferencing, and that was held in State of Maharashtra versus Praful B. Desai in 2003. State of Maharashtra versus Praful B. Desai 2003. Here it was held that evidence can be both oral and documentary, and electronic records can be produced as evidence. Thus, the means of collecting evidence through video conferencing, even in criminal matters, is acceptable. That was held in State of Maharashtra versus Praful B. Desai in 2003. And the next we have is circumstantial evidence. For conviction on circumstantial evidence, the following conditions must be fulfilled. 1. The circumstances from which the conclusion of guilt is to be drawn should be fully established. So it should be fully established that the person is guilty. That is the first condition. And the second condition is that the facts so established should be consistent not only with the hypothesis of the guilt of the accused, but they should not be explainable on any other hypothesis except that the accused is guilty. So every probability or every hypothesis should show that the accused is guilty. Then the circumstances, the third one, the circumstances should not be conclusive nature and tendency. Should be of conclusive nature and tendency. There should not be any reasonable doubt or any other probability. Now the fourth condition is they should exclude every possible hypothesis except the one to be proved. And the fifth one, there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have done by the accused. And all these five conditions for conviction on circumstantial evidence, for the conviction on circumstantial evidence, was laid down in Sharad Birdhichand Sharda versus State in 1984. Sharad Birdhichand Sharda versus State, AIR 1984. In this case, the court laid down 5 conditions to be met when conviction on circumstantial evidence is to be done. So the first one is that the conclusion of the guilt must be fully established, and the facts should be consistent with all the fact or the hypothesis should be consistent with the guilt of the accused. And the third one, the circumstances or the explanation should be conclusive nature. And the fourth one, there should not be any possibility that there is only one possibility. All the hypotheses show only one thing to be proved, and there is only one possibility. And the fifth one, there is not even a single probability or possibility to show that the accused may be innocent. So all the inference, all the hypothesis, everything should be to show the guilt of the accused, and that is to be proved. All should point towards the guilt of the accused. Only if that is all these conditions are satisfied, a conviction on circumstantial evidence can be done. And that was held in Sharad Birdhichand Sharda versus State. SHARAD, Sharad Birdhichand, BIRDHICHAND, Birdhichand Sharda, SHARDA, Sharda. So Sharad Birdhichand Sharda versus State 1984. Now there are some other cases too that referred to the same standard based on this case. The one is that Sudama Pandey versus State in 2002. So this was a landmark case that came in 1984 based on the same decision. Court made decisions in Sudama Pandey versus State in 2002, and then Subhash Chand versus State in 2002, Ashish Batam versus State in 2002, and then Bhagat Ram versus State of Punjab in 1954. Then Kusuma Angama Rao versus State of AP in 2008. So we can quote either of these cases with respect to these conditions and conviction on circumstantial evidence. The latest case given here is Kusuma Ankama Rao versus State of AP. That is with respect to the Bear Act, where under the cases discussed under Interpretation Clause Section 3 Evidence Act in the Bear Act. Now, a conviction on the basis of circumstantial evidence is permissible only when the circumstances relied upon are proved beyond doubt and are incompatible with innocence of the accused. That is a most important point that was held in Chattar Singh versus State of Haryana in 2009. So that is the whole of the 5 conditions in a single statement. That is, the circumstances relied upon are proved beyond doubt and are incompatible with innocence of the accused. That is what the court is looking for. So, a conviction on basis of circumstantial evidence is permissible only when circumstances relied upon are beyond the doubt and are incompatible with the innocence of the accused. That was held in Chattar Singh versus State of Haryana in 2009. Now, the next expression that is discussed under interpretation clause here is variation between medical and ocular evidence. Now, minor variation between the medical evidence and ocular evidence do not take away the primacy of the latter. So, it does not take away the primacy of the ocular evidence if there is a minor variation with the medical evidence, unless medical evidence in its terms goes so far as to completely rule out all the possibilities whatsoever of injuries taking place in the manner stated by the eyewitness. So that was held in Kamaljit Singh versus State of Punjab in 2004. In Kamaljit Singh versus State of Punjab in 2004, the court held that if there is a minor variation with the medical evidence and the ocular evidence, that is immaterial. But if the medical evidence rules out all the possibility of getting injured in the way as the ocular evidence states, then the medical evidence is given priority and the primacy of the ocular evidence is taken away, and that was discussed in Kamaljit Singh versus State of Punjab 2004. Now, it is tried that where the eyewitness's account is found credible and trustworthy, medical opinion pointing to the alternative possibilities is not accepted as conclusive, and that was held in State of Madhya Pradesh versus Dharkole. State of Madhya Pradesh versus Dharkole in 2005, as well as in Ramakant Rai versus Madan Rai in 2004. Ramakant Rai versus Madan Rai in 2004. That is, it is tried that where the eyewitness's account is found credible and trustworthy, medical opinion pointing to alternate possibilities is not accepted as conclusive. So it is not that the medical evidence rules out the possibility of otherwise, an incident happening otherwise. The medical possibilities contravening the eyewitness statement, which is credible and trustworthy, will not be accepted as conclusive. It will be accepted as relevant but not conclusive. So that was discussed in State of Madhya Pradesh versus Dharkole 2005. Also in Ramakant Rai versus Madan Rai 2004. Now, the last expression discussed under interpretation clause is evidence and the ambit of. Now, deposition made by a witness during the course of the trial of a sessions case is certainly evidence within the meaning of the expression as defined under section 3 of the Evidence Act, and that was held in R. Dinesh Kumar versus State in 2015. In R. Dinesh Kumar versus State in 2015, the court held that deposition made by a witness during the course of the trial of a sessions case is certainly evidence within the meaning of the expression as defined under Section 3 of Evidence Act. Now, that is with the interpretation clause, that is Section 3 of Evidence Act 1872. We have discussed all the case laws, the explanations, the illustrations, all with respect to the Bare Act. Thank you. Stay tuned, and I'll be updating the. We'll be continuing with the rest of the sessions and important sessions and topics in the following parts. So stay tuned, like, subscribe, and don't forget to click that bell icon so that you get an update whenever I upload a new video or a new session. Thank you. Bye.